Welcome to our today's open talks about the new rules on the prevention and combat of money laundering and terrorism financing in the real estate sector. Today, we will talk about the new regulation 603 from 2021. And my name is Pedro Gonçalves Pais. I am the partner in charge of the international operations at RSA, Raposo Subtil and Associates. First of all, I would like to thank to the support that we received from Remax and also from Max Finance with all the communication and promotion material, and also the support, and that is the reason why this is in English, from our network, our international network, the Next Law Network, because they provide all the marketing material and all the promotion that we receive from them. So, last 15th of July of 2021 came to enforce the new regulation 603 from 2021 that established and regulated procedures to be adopted to the fight against the money laundering and also the terrorism financing in the real estate sector. That is the reason why we are here, and that is the reason why we will explain a little bit about that. This session will address matters involving compliance with anti-money laundering and terrorism finance requirements, such all activities related with real estate brokerage and the purchase and sale of real estate. As you know, the compliance with the prevention requirements is very important today in the current legal and regulatory framework, which impose duties on the employees of all organizations like yourselves, the Remax and Max Finance, starting with their directors and top management. Having this regulation in mind, we will discuss today live the practical issues on the real estate sector and will answer to some of your questions. As a matter of introduction, our law firm, RSA, Raposo Subtil and Associates, is based its activities on a completely integrated services for its clients at both national and international levels, combining an extensive knowledge of business with the necessary technical expertise in terms of real estate matters, compliance, criminal law, and all the issues of investment related with the golden visa. Our office, we have office here in Lisbon, and we have office also in Algarve, Coimbra, Porto, and Madeira. We have also an international network that is RSALP, that covers all the Portuguese speaking countries, namely in Angola, Mozambique, Cape Verde, and Macau, and also São Tomé. And Brazil. So, together with some lawyers of my office, namely Manuel Nobre Correia, that is here together with me, and also Sara Minhalma, that is on the screen, coming from Algarve, we will present the new rules on the prevention and combat of money laundering and terrorist finance in the real estate sector. Please, Manuel, take the floor and give some words to our
Thank you, Pedro. Hello, welcome everyone. As Pedro, warm my thanks from the kind introduction you made on my regard, obviously. As Pedro said, my name is Manuel Nobre Correia, and I am a principal lawyer at RSA in the Criminal Law and Compliance Department. I practice law for over 20 years with a special focus on criminal and civil litigation. In these past years, in these recent years, I have regularly represented Portuguese and foreign clients, both natural persons and companies, singular persons and companies, in criminal and also administrative offense proceedings related to economic crime, what is called commonly as white-collar crime. Within this team, I have dedicated special attention to the sanctioning of money laundering, an area, when I say money laundering, you must read money laundering and terrorist financing, because it is for short money laundering. This is an area in which I have provided training to employees of both public and private entities, and also trainee lawyers, as well undergraduates from some universities. After Pedro's introduction, and given the format of our initiative and the time available, because we have not that much time, we have about 1 hour,
yes.
And also the number of questions we already received via email throughout the week we can only address the essential issues without developing these issues in depth. This means we will name the key issues, but not develop profoundly. Thank you for this opportunity to be with you, and I return the floor to Pedro.
Okay, well, thank you very much. Thank you very much for your introduction. It is very kind from your side. So, and now we have from Algarve, Sara Minhalma. Please, Sara, feel free to say some words to our friends from Remax and Max and Finance.
Thank you, Pedro. Good afternoon, everyone. Thank you for attending our webinar about such an important subject. As my colleague said, my name is Sara Minhalma, and I am an associate lawyer of RSA law firm in Algarve. Our office is located in Almancil, and we assist and advise clients in most areas of law, especially regarding real estate investments, the Golden Visa program, and other types of obtaining legal residence in Portugal, the non-habitual resident status, for example, as well as general litigation, asset management, local accommodation, labor, social security, corporate governance, among other services. As you all know, the Algarve is a very popular and attractive destination for real estate investments and Golden Visa program, which means that all the real estate sector entities that practice real estate brokerage, for example, or the purchase and sale activities, must comply with the new IMPIC regulation in force and adopt all the legal procedures to prevent money laundering and terrorist financing. Therefore, I now pass the word to my colleague Pedro, so we can start right away the discussion of our webinar's subject. Pedro.
Okay, thank you very much, Sara. And I will explain a little bit about the dynamics of this Q&A section. So today, the session will be open to everyone. Everyone will have the opportunity to use the chat box. Please use the chat box to put your questions. And then if we will have time, we will answer to all the questions. If we do not have time, we will send you by email our answers, okay? So in the end of the session, we also will share with you by email our RSA ebook with all the legal framework on anti-money laundering with the law 83 from 2017, with the amendments of the law 58 of 2020, and with all the comments that we have and all the notes to these laws, and special with this new regulation that we will discuss today, the regulation 603 from 2021. So what I will ask you is during the session, please share your email address on the chat box. Then we could prepare an email with this ebook that we have it, and will be a very good weapon for your future problems and for your future work, okay? Thank you. So as an introduction to this session, it is important to explain that the prevention and the combat of money laundering and the terrorist finance in the real estate is a very serious matter in Portugal and in the world. And as a result of that, the regulation 603 from 2021 was approved by the governing board of the Institute of Public Markets, Real Estate and Construction IP, namely the IMPIC, and came in force the last 5 of July of this year, so it's very recent. So the aim of this regulation is to establish and regulate the procedures to be adopted in the fighting against the money laundering and the terrorist finance in the real estate sector. This regulation revokes the regulation 276 from 2019 of 26th of March, but retains, and this is very important because Manuel will explain, and also Sara, but retains most of the existing rules. This is very important to bear in mind. As a result, the obligations to continue to apply to entities which is regardless there are or not finance or no finance engaged in Portugal in material acts in the real estate agencies, the purchase, sale, and purchase for resale or exchange of properties, the property development, and also the property rental, sorry. So what this is the obliged entities. As a part of the effort to adopt measures to fight money laundering and terrorist financing, the regulation has in general reinforced the existing procedures as I explained. But the most important of the obligations that apply to obliged entities are the duty of control, the duties of identification and due diligence, this is very important, the duty of retention, and also the duty of communication. My colleagues will explain in greater detail some of these duties in questions that we received during this week. We receive questions from across Europe and all over the world, and we will answer directly that question that will help you to understand this regulation. Finally, you must also note that the range of entities that must appoint a member of their senior management or equivalent to act as the compliance officer for the legal and regulatory provisions applicable to fighting money laundering and terrorist financing has been also extended. The compliance officer now acts as the main point of contact between the obliged entity and also the IMPIC regarding compliance and matters related with the regulation. Now, all the obliged entities that I explained before are subject to this obligation to appoint a compliance officer regarding their legal nature, providing that they have more than five employees in their commercial and administrative areas. After this introduction, and as a kickoff for the Q&A of today, of these open talks, as I said, during last week we received several questions, and some of them we will answer immediately. So we have here a very good kickoff question for Manuel. We received this question from UK, from our colleagues in Britain. So the question is, Manuel, which entities, the obliged entities, are subject to the legal duties stated in the norms and provisions fixed in the regulation 603 of 2021?
Thank you, Pedro.
Okay.
This is an excellent kickoff because, first of all, we must know to whom it applies the regulation we are talking about. Not only the regulation, but also the supposed laws by the regulation, because there are a lot of laws. There is a whole legal framework beneath the regulation. The regulation is, let's say, the narrowing of the common obligations towards all the entities in the real, not only in the real estate world, but also in all the activities to whom it applies. But regarding this question, which entities are subject to the legal duties
yes.
Of the regulation? Obviously, the obliged entities, for short, we are going to refer only obliged entities. Obliged entities of the real estate sector are those entities who have some relation with the real estate activities in Portugal. These legal duties stated in the norms and provisions fixed in the regulation 603-0/2021 are applicable both to financial and non-financial entities that carry out real estate activities in Portuguese territory, in Portugal, which we call real estate entities. This means independently from being financial entities or non-financial entities, any entity, meaning real estate brokers or companies or even natural persons, singular persons, are subject to the provisions of Regulation 603/2021, providing they develop their real estate activities in Portugal. For this purpose, it is assumed that such entities perform real estate activities in Portugal whenever they perform acts of real estate brokerage, which is, I'm sure of it, you are all familiar with, because most of the people I see attending this session are real estate brokers. The activities of purchase, sale, purchase to resale, or exchange of properties. meaning covering all the real estate operations available in the catalog. Also, real estate development, which is defined as promoting, programming, managing, financing, either directly or indirectly throughout a third party, with own resources or some other people's resources, the construction of buildings with the purpose, with aiming later to transfer or sign those buildings to another entity, notwithstanding the intended purpose of the title on the leasing real estate. So we define now which are the operations that are subject to this regulation. Now, whose companies or entities do we consider to being operating in Portugal? Any company or entity whose laws or bylaws or the fact main office is located in Portugal. Meaning, if my bylaws say that my head office is in Portugal, we are automatically subject to the regulation. If my de facto main office, even my bylaws say that my head office is in, I don't know, in Gibraltar or Channel Islands, whatever, but the de facto, my main office, my head office is in Portugal, so I am subject to the regulation. And obviously, these entities, being companies or being natural persons, they only are subject to the regulation when they carry out in Portugal the above mentioned activities, real estate activities, the activities I mentioned before that refer to real estate operations through branches, agencies, commercial delegations, or any other form of permanent local establishment. Meaning you don't have to have a registered office here to be subject to the regulation. The application of the regulation is defined by the nature of the operations you aim to in your activity.
Okay, good. Thank you very much, Manuel, for the good explanation. We receive here a question, a very important question from Macau in China for Sara Minhalma. Sara, please explain and answer. What are the main change provided for the new regulation 603/2021 compared with the previous one, the regulation 276 from 2019? Please, Sara, go ahead.
Thank you, Pedro. As mentioned before by my colleague Pedro, the new regulation in force since July 5 revoked the previous regulation. However, most of the rules and procedures of the previous regulation remained unchanged. The most significant changes that this new regulation established were: number one, on Article 5, paragraph 1C and D, it extended the scope of the duties of customer identification and due diligence, which were already provided for in Article 23 of the Law 83 of 2017, which is the law on prevention and repression of money laundering and terrorist financing. On the other hand, the duty of communication provided for Article 20, paragraph 1 of the new regulation also suffered some important updates, namely the mandatory communications of real estate transactions and lease agreements whose the monthly income is equal to or greater than 2,500 euros are now made quarterly, each 3 months, instead of every 6 months. This change can also be verified in number 2 of the Annex B form, which is the approved form provided for the regulation for this type of mandatory communications, as most of you all know. So in practical terms, the communication of business made in the first trimester of the year must be done until June 30. In the second trimester of the year, must be done until September 30. In the third trimester of the year, must be done until December 31, and the communications of businesses made in the last trimester of the year must be done until March 31 of the next year. These are the main changes of the duty of communication. Another relevant change is related with the compliance officer, and you already mentioned this, Pedro, in your introduction, and very well. Article 10 of the new regulation stipulates that the entities which carry out real estate activities in Portugal, whatever their legal nature, and whose number of employees in the commercial or administrative areas exceed 5 people, must designate a compliance officer. This did not appear on the revoked regulation, the minimum amount of employees in these areas. As you may all know, the compliance officer should be a member of the top management of an obliged entity or a person treated as such, for example, a manager or any employee who has sufficient knowledge of the exposure of the concerned entity to money laundering or terrorist financing, and holds a sufficient high position in terms of hierarchy to make decisions that affect the exposure to the risk. And it's appointed by the board of directors, and it's a person that should be responsible for supervising compliance and the existing legal and regulatory framework on preventing money laundering and terrorist financing. Article 10 of the regulation also stipulates that the compliance officer shall be the privileged contact person between the company or the obliged entity and INPIC, but, and this is new, it should be also the privileged contact person between the company with the competent police and judicial authorities in the matter and the areas of preventing and fighting money laundering and terrorist financing. Finally, just to finish the answer, the freezing of funds and economic resources is now admissible as a restrictive measure provided for in Article 13 of the new regulation. These are the most important and relevant changes of the new regulation of INPIC.
Okay, Sarah, now thank you very much. I think we have also 2 questions for you coming from Spain. The first one is related with the compliance with this new regulation. And the question is how to act in compliance with the new regulation if a client who intends to buy real estate for the golden visa application refuses to present all the legal required identification data. Please, Sarah.
Okay, thank you. Well, the obliged entity or the person who works for the obliged entity that carries out the real estate activities must comply with the duties of customer identification and due diligence provided for in Article 5 of the new regulation. And what is exactly the duty of customer identification and the duty of due diligence? Nothing more than the obligation for the obliged entities to follow identification and the due diligence procedures with regard to customers, their representatives and beneficial owners. In these cases that I'm going to mention now, when establishing a business relationship, when carrying out occasional transactions amounting 15,000 euros or more, whether we are talking about a transaction that is executed in a single operation or in several operations which appear to be linked. Also, when there is a suspicion that the transactions might be linked to money laundering or terrorism financing, regardless of their value or any exception. And when there are doubts about the veracity or the adequacy of previously obtained customer data identification. Now, these 2 last cases that I've just mentioned are the result of the extension of the scope of the duties of customer identification and due diligence provided for the new regulation. What do they mean? They mean that the obliged entities, or again, the people who work for the obliged entities, have even more discretionary and subjective judgment in the assessment of a suspicious transactions or false costume identification data to prevent and fight money laundering or terrorism financing in the real estate sector business. This is a very important change of this new regulation.
Okay, thank you very much for the example. It was very clear. From the same office in Spain, we have also the second question, and is related also with the identification. And the question is, how do the obliged entities verify the identity of their customers? This is very important to explain to the people here in the room. Please.
Yes, I will reply this question in general, because these duties have a lot of requirements. But for example, for natural people or their representatives, the identification shall be made by collecting and recording the identification elements from valid identification documents, such as the passport, citizen cards, for example. And the elements are, namely, the photograph, the full name, the signature, date of birth, the nationality, as indicated in the identification document, tax identification number or TIN number, or where it does not exist, the equivalent number issued by a competent foreign authority, the occupation of the natural person, if applicable, the full address of the permanent residence, or if different, the tax address of the natural person, the place of birth, other nationalities not indicated in the identification document. And as for the representatives of the natural person, the obliged entities shall also verify the document that empowers them to act on behalf on their customers' behalf. For example, I can remember a power of attorney. Regarding, if we are talking about a legal person or a company and their respective representatives, the identification shall be made by collecting and recording the identification elements from the legal person identification card, from an extract from the commercial register of the company, or any comparable document from an independent, reliable source when the respective head office is located outside Portugal. And those elements are, for example, business name, the object, the full address of the head office, and when applicable of the branch or permanent establishment, as well as, if different, any other address of the main places of business, the legal person number, or if it does not exist, the equivalent number issued by a competent foreign authority. It is also necessary to identify the shareholders who have shares representing 5% or more of the capital or the voting rights. Also to identify the members of the board of directors or an equivalent body, as well as other relevant senior officials with management powers. Another important element, the country of incorporation, the CAI code. And for the representatives of the entities, of these companies, the obliged entities shall also verify the document that empowers them to act on their customers' behalf. Now, I want to say, this is important. As a rule, the proof of identity must take place before the establishment of a business relationship or the performance of any occasional transaction. That is, in the particular case of real estate mediation or brokerage, at the time of execution of the contract for the provision of real estate mediation services, what we call CME, and always prior to the execution of the promissory agreement or the public deed. And I want to give also a very important example. This can happen, I'm sure it already happened with you. If two real estate agencies with separate customers, for example, buyer and seller, or tenant and landlord, participate in a real estate transaction or lease agreement, both entities are required to perform the identification and due diligence procedures in accordance with the common rules, with regard both to their customers and to the other stakeholder or party in the property transaction in which they participate. In addition to the identification procedures, the obliged entities should also adopt some due diligence procedures, such as they must obtain information on the purpose and intent nature of the business relationship. Also obtain information on the origin and destination of the funds handled in the context of a business relationship or an occasional transaction when this is justified by the risk profile of the customer or the nature of the transaction. And also conduct ongoing monitoring of business relationship to ensure that the transactions being conducted throughout the course of the relationship are consistent with the obliged entity's knowledge of the customer's business and risk profile, including, where necessary, the origin and destination of the funds handled. And now, just to finish my answer, although I have just spoke in general terms about the duties of customer identification and due diligence, what I wanted to convey is the importance of having an updated file with all the valid required customer identification data, along with a know your client form, of course, with data, which, by the way, you must keep for a period of 7 years. And never forget, as entities or people who work for entities of the real estate sector obliged to comply with the new INPIC regulation, you have the important role to make a subjective judgment in the assessment of suspicious transactions or possibly fake customer identification data to prevent any acts of money laundering or terrorism financing. I'm sure that a lot of you already have worked or are working with the purchase and sale of properties for golden visa investors. So you must comply with these two duties very carefully, because we are talking about third country foreign citizens, and some countries you must make the judgment if the country is a country where exists money laundering or terrorism, and pay attention and comply with these duties very carefully, because any suspicious acts, if you think that the data that the client provides you is not real or it seems to be fake, ultimately you should report to INPIC. You have in Annex C of the new regulation just a few examples of suspicious acts that ultimately you have to report to INPIC and also the competent authorities, because you have this obligation even if you take the risk to lose the business.
Okay, Sarah, thank you very much. It was great.
Pedro, if you allow me, just to stress some key points on what Sarah said, which are most important. We must understand all that as time goes by, the legal framework gets more strict, gets more, let's say, less permissive than before. This means that the obligations that the obliged entities are subject are more and more and more demanding, are more important. So what Sarah said can be exemplified very easily. prior to these changes, we were not obliged to report on some activities if you were just at one end of the deal. For instance, if you are the buyer and the seller, okay. But if you are only the one who gives a bond for the deal, you were not identified as part of this deal. You understand me? So I'm offering a guarantee for this deal. I am not identified as a member of this deal. Today, the real estate brokers have to be very attentive because they have to identify not only the direct participants in the transaction, like the buyer or seller, but also people who act not directly, but on behalf of some of the parties. So these sort of obligations are much more demanding, as I was saying. And also, before this last change to the law of money laundering, the 83-2017, which has been very recently reformed by the law 53. But anyway, before this last reform of the legal framework, we were only obliged to report what we call the suspicious operations. You understand me? When we had some evidence corroborating that this or that operation was somehow suspicious, we have some motive to believe that this operation was suspicious, or either because the money came from what we call a risk jurisdiction, namely some countries in Asia, some countries in Africa, which are considered risk for money laundering. Well said. This means that some countries are listed in a list made by the European Union or even the UN, saying that these countries represent a high risk of money laundering activities being held over there. So when we receive from some African countries or some Asian countries funds to perform a real estate operation, let's say to buy a property, an equity, not for the purpose of golden visa, but for any other purpose, if we do not report instantaneously this operation, even though the funds are perfectly traceable, we know its origin, we know what the people behind the money, but even so, if they came from that jurisdiction, risk jurisdiction, we have to report it. And also, our duty to report are not only suspicious operations, meaning operations that we have motives, evidences to support the suspicion that that operation can be related to some money laundering activities, but also when we have funded reasons, and we have to be very attentive, we have funded reasons, we have reasonable reasons to consider that operation as suspicious, meaning we don't have to have any evidence. We just have to have a reason to suspect that this operation may be related to some money laundering activity. So what I am saying is that this sort of regulations continuously are going to narrowing the provisions in order to increase the obligations of the real estate brokers. You understand me? They made, I'm sorry for these words I'm going to say, but this is the truth. The law makes us all police officers in what concerns the real estate sector, real estate market, doing the work of the police and also the public prosecutor's office. Meaning we are now all spying on every operation we perform. So these obviously, and I will, sorry for this my interruption in the Q&A.
No problem.
We are all duty bound to report on anything that goes through our offices. You have offices where clients like a lot. For instance, everyone who has done real estate operations with foreigners, with non-Portuguese investors, know that these investors often like very much their confidentiality. They don't like to their identity be known to everyone. They don't like their names to be on a list sent to the public prosecution's office, or better, the central office for prosecute, in Portuguese, the SIAP. So many people ask to you as brokers not to allow to divulge their identities, and you are confronted with these requests, and also on one hand, and on the other hand, you are confronted with the obligations you have to comply with via the regulation and also the money laundering law. So I must urge everyone here, every broker which is present here, to be very attentive, because very often the breach of these obligations established by the money laundering law and also the regulation leads to a criminal charge. You have to be very attentive. At the least, you will have an amendment. May have to pay contravention, at the very least. But when I say a very least, not really very least, because today we have contraventions that are in order of millions. You understand me? So everyone is subject. If you breach with these provisions of Regulation 603, you are subject to be facing criminal charges, as well contravention issues, which can amount to the application of amendments of over 1 million euros. So this is no joke. We have really to comply with these provisions. I'm sorry, Pedro, I tried to be very fast, but this is very important.
No, it was very helpful, because I think what you explain is what some of the people that are on the other side asking, and what I can do, what I should do, what I cannot do. So we have here a question for you. So it's also from a European country. It's from Italy to you, to Manuel Correa. And the question is very simple. For the entities with real estate activities, what does the IMPIC regulation establish as regards the reporting of irregularities? Please.
Thank you. This is obviously related to what I was saying. One of the most important, besides the identification of the customers, of the clients, and the due diligence we have to exert towards the client. So we have to investigate where the client is from, what is the real person behind that company, etc., etc. We are duty bound to investigate our own client. Besides that, client identification and due diligence, I must say that the most important of the duties we are subject to are the duties of reporting irregularities. This means that we have to report to the supervisory authority, in our case IMPIC, the Real Estate Markets Institute. We have to produce a report, either if you have irregular or not operations to report. So in general, the supervisory authorities may demand the obliged entities which are under their jurisdiction to produce a report with the contents and the frequency that is defined by that same authority, including a description of the channels those anonymous channels, internal channels that every company must provide to their employees and clients, enable them to report anything that seems dubious or suspect during an operation. This means that employees have to be provided for with a channel to report internally these sort of operations, internally and, most importantly, anonymously. So our own employees, you have an agency, medium-sized agency with 2 or 3 offices, with 20 brokers, and you have to provide for, in your office, you have to provide for an email, a blog, a WhatsApp account or something, but produced in a way that the people who place some information there can remain anonymously, can provide these anonymously, so in order not to be known by his entity, meaning the most simple example and most traditional example is of the box with a small hole enabling people to push papers down there. So you are going to the bathroom and you have this box in the door of the bathroom, so you put a paper saying, I saw a very suspicious operation because the other day Sarah received some Chinese people, and these people seem very dubious because they brought money in bags, in the supermarket bags, and Sarah should have reported this to the compliance officer and didn't do it. So I have to communicate this dubious situation to whom it may concern, namely the legal representative of this company. But anyway, these channels are provided for in the law of money laundering. I want referring to the law of prevention and repression of money laundering and financing terrorism because it's too long. For short, I will imply the money laundering law, and that's enough. So, the money laundering law makes mandatory to everyone to create channels, appropriate channels that enable every employee or people who contact with this company to depose a complaint, not a complaint, but something that seems suspicious. These channels are provided for in the money laundering law, and regarding these channels, every year, this is most of the supervisory authorities ask a yearly report, but they may ask a monthly report, and the INPIC, I think, asks every month to every broker to produce a report with the content of with this content. First, what channels were created for this purpose? Secondly, make a small brief of the reports received and their proceeding, name not the denounces, but the complaints that were deposed on these channels. So we have to explain which channels have you created, and also what complaints have been made through these channels. This is what in general it's applied to the sector. The INPIC regulation narrows down these obligations, establishing that the obliged entities shall draft an annual report containing a description of the specific independent and anonymous channels created for this purpose, a brief of the internal reports received. When I say reports, I say complaints. There are more complaints than reports. But thirdly, I have to stress that not all real estate entities we are talking with are required to appoint a compliant officer. If you have less than 5 employees, you may not legally appoint a compliance officer. You are only obligated to appoint a compliance officer if you are over 5 employees in your office. So if you are not obliged to require to appoint a compliance officer because of the size and structure of your company, this report should be drafted by the legal representative. In the other cases, the report shall be drafted by the compliance officer because it is his duty, it is his role. Those reports are made permanently available to IMPIC. This means that whenever the IMPIC wants to consult them, you have to provide them to the IMPIC. We have to give free access to the IMPIC for access to these reports. Finally, the compliance officer also provides the compliance with another sort of obligations deemed useful by obliged entities.
There is here a very curiosity from someone question. It says, no irregularities are reported as regards the compliance by the entity with the procedures that you described. The question is, it is necessary to draft any document in this case? Imagine this example.
Yes. Even though you may not find any irregularity, this is why I say that these regulations tend to transform all of us in police officers, prosecutors, etc. Why? Because we have to say, always have to report anything. Even though we do not find any irregularity in our operations, in the operations made through us, we have to provide with a document. This document has to be prepared by the compliance officer also, and or the legal representative if they don't have the obligation to appoint a compliance officer. And imagine that there are very few, but there are some brokers which are acting only by themselves. They are the sole traders. You understand? When they are acting only themselves. So everyone has an obligation, the compliance officer in companies with over 5 employees, the legal representative in companies below 5 employees, and the sole trader or an appointed employee have to produce a document, a report, mentioning that there are these channels that the law require, and these channels of communication of irregularities. They didn't receive any irregularity, but they have to report that they have these channels, okay? Yeah. And they have to refer that they don't have any irregularity to report.
Yes, you already mentioned some of the entities, but someone asked this one. What entities are obliged to report the real estate activities to IMPIC? You already explained, but okay. Repeat, because this is a current issue, a current question from our friends.
Okay, in short, everyone. Everyone is obliged to report any irregularities. Everyone that works in the real estate sector, okay? The laws say this, everyone is responsible. Now, in this case, the direct responsible is this person, the compliance officer. In that case, is the legal representative. In this case, is that person, etc., etc. But to give a more, let's say, a more official answer, I must say that all the entities that carry out the real estate activities or provide real estate brokerage services, that purchase, they sell, they intermediate the sale, they intermediate or they directly purchase for resale, for the intent of reselling, or they exchange real estate, or they lease. Leasing is very important because we are forgetting about the landlords we represent. When there is a leasing in question, we also have an obligation to report. So everyone who acts on the real estate world, adding real estate operation is obligated to report any irregularities, or to produce that document that when there are no, in the event there are no irregularities, they have to produce that document I referred to before. So everyone that acts on the real estate market conducting one of these operations is obligated.
Yes, we are in the end of our time, but I think we will have time for two more, the last one, two more questions. Three? Do you think that we will have for three?
Yeah.
So, but as I explained in the beginning, please send your questions, put the questions in the chat box. We will not have time to answer to some of them, but we will have, after this session, the opportunity to send you by the email the answer to your questions. Please also put your email on the chat box, that we also will send you the ebook from RSA with the legal framework and all the laws, with our comments and notes, all the laws that we are explaining here. So we will send you by email. So we have here a question that is in line with what you are explaining. Are unincorporated partnerships obliged to report real estate activities?
Yes, they are. This is very important because sometimes we tend to believe that if there is an informal partnership, we are not obliged, we are not bound to report anything. But we are obliged to report regardless we are an unincorporated or unincorporated partnership. Meaning, let's suppose, give a very common example. I am the proprietor of an equity, I have a property, okay? And next to me is Pedro, which is a developer, okay? So we do not incorporate the company, but Pedro says, okay, you give your land, your property, and I will build on this land, and we will divide the profits in half or something. You understand me? So when we do this, and at the same time we invite Sarah as a silent partner to provide to bring some funds into this informal partnership, obviously that the people who are mediating these operations, these transactions, not only selling the flats that we are going to build, understand me, but also saying that we had an informal partner, a silent partner that is named Sara Minhalma, which is a millionaire from Algarve and wants to invest in this project. But Sara has a relation to someone who is linked to a risk jurisdiction, so we have to report this issue. So whenever you are carrying out real estate activities, you are required to comply with the obligations provided for in the law of money laundering, and this regulation seeks to agree, regardless you are an informal partnership. So everyone is subject to this legal framework.
Good. We have here, I think maybe the last one, I don't know if
before the last.
Before the last one, we have here a small example. It's a short case that someone described, and it says, as a part of my company business, I purchase, sell, and lease properties, but these activities are not included in the description of the company's object. I am obliged to comply with the obligation to report the real estate activities according with this regulation, Manuel?
Yes, obviously. As I said, everyone and everything. Everyone, you have to retain this. The key to understand the obligations, you are obligated by everyone is obligated, and you are obligated to do everything. So, The concept of real estate activity provided for in Article 2 of the IMPIC regulation, Regulation 603, means in practice that carry out material acts corresponding to real estate brokerage, purchase and sale, purchase for resale, exchange of property, lease, etc., real estate development, Pedro's specialty. It should be reported after the date of the first material act implementing these activities. This means what? This means that even though it is not something that is a part of your registered activity, when they say that does not part of their object, they are meaning that these real estate activities are not in the deed of incorporation, mentioned in the deed of incorporation. Sarah talked about CAI, which is the description of your company's activity. So even though you don't have real estate operations in the CAI you choose, if it's enough to conduct a real estate operation to make you subject to these obligations. We have time for one.
Yeah, the last one. Sorry for not answer to all of your questions. This will be the last one, but please put your email on the chat box, send your questions, and we will answer after the session, and we will send you the ebook that I promised to you. So the last one is for Manuel also.
I'm sorry, Pedro, I'm sorry, because this is the last question. I took the floor from our moderator / speaker, and I will choose an answer to be the last answer to be given in this session, because this is really very short, few time. We don't have time to give you an hint of what is required from the real estate operators. So there is someone here who asked me if there are any other rules that apply to the real estate brokers. Obviously, yes. We have mainly the law of money laundering, the law 83/2017, which provisions apply to all the real estate agents or operators. And this law establishes a lot of obligations that we cannot, because I don't have more than 2 minutes to talk, and I cannot explain all of these obligations. But these obligations are, just to name a few, the control obligation, the obligation to verify every operation that you attend to, the appointment of a compliance officer and the reporting of the compliance officer to the IMPIC, the drafting of the annual communication of reports on the internal in-house channels for reporting irregularities and related occurrences, the implementation of restrictive measures applicable to individuals, entities, or countries as established by the national and international organizations, namely the UN or the EU. The client identification and due diligence obligation that Sarah developed above, the obligation to keep documents and records. Attention everyone, you have to keep every paperwork related to these obligations you have to keep for a very large number of years. So please do not throw away the paperwork related to a given operation after the operation is completed and perfect. You have also, this is more important, you have the obligation to train your own employees and your own partners in these obligations. So you have to explain to everyone. Obviously, you have the obligation provided for in the Article 46, you have to report of real estate activities. And finally, you have to let's say, you cannot say that you don't have capacity to absorb everything we are saying. You understand? Not knowing the law does not help you. This is a very traditional and very well-known legal adagio. We cannot profit from not knowing the law. So you cannot invoke, but I didn't know I have to appoint a compliance officer. You have to make your business to know that you have to appoint a compliance officer. So everyone, my advice is please talk to your lawyers and ask them to provide you with a brief of the obligations you are subject to. You understand me? You have to ask the lawyer to say, what are the main obligations I have to follow? What are the main obligations I have to comply with? And please explain me this as I am a 6-year-old. Do not speak in legal gibberish. Please speak in a plain language and explain me in a plain language what I have to do to be within the legal framework obligations. This is, I think, this is my final advice to you, and this is most important to you. You cannot continue to act like an ostrich and disregard these obligations set in the provisions of this IMPIC regulation, as well the obligations emerging from the general law on money laundering. You have to make your own interest to know about these obligations. So please talk to the lawyers. Thank you.
Okay. Thank you very much, Manuel. I don't know, Sara, if you want to add something.
No, thank you again for attending our webinar. I have seen a few questions here in the chat. We will answer properly by email.
Okay.
I hope to see you in another event.
Okay. Thank you, Sara. Thank you very much for all the attendees. I hope to see you in the next open talks. We are also prepared for the REMAX and Max Finance Group a session on these matters, exclusivity for the REMAX and the Max Finance Group. You will receive the details. It will be next month, and I hope that we can see you again there. Thank you very much. Thank you, Manuel. Thank you, Sara. Have a nice day.
Thank you.
Very much.